Good afternoon, ladies and gentlemen. On behalf of CESA, I'd like to extend a warm welcome to our members and those viewers who have also joined us today for the fifth of the webinars in the series on the newly revised CESA Practice Notes. This webinar is entitled Construction Stage, Tenders, Administration and Claims, Best Practice. I will be your moderator for this webinar, so kindly allow me to introduce myself. My name is Wally Main, and I'm a civil engineer occupying the position of Contractual Affairs Manager at CESA. This webinar will be followed by two similar CESA webinars on the 6th of April and 18th of May this year. It will each deal with one of the remaining categories into which the practice notes have been divided. And as well, they may deal with some of the practice notes in depth. You're kindly requested to share this information with your colleagues. In other words, news of the forthcoming seminars or webinars. You will have noticed earlier in the holding slide details regarding the Business of Consulting Engineering program, which we fondly call the BCE, which is an additional resource available to you. The BCE is the flagship of the CESA School of Consulting Engineering, and it encompasses much of the detail and principles of the CESA Practice Notes. It is highly recommended that any engineers wishing to advance their careers in the consulting engineering sector kindly consider registering for the CESA BCE program. It is well worth your while. For details of the BCE program and the many training courses offered by the School of Consulting Engineering, kindly click on the training heading on the CESA website. I'd also like to inform you that the webinar is being recorded and that the presentations will be available after the webinar on the CESA website, and you can click on the headings Guidelines, then Presentations, then CESA Practice Notes webinars. Before we get started, I'd like to outline some of the house rules for our delegates and viewers. On the taskbar at the bottom of the screen, you will see the chat and the Q&A icons. Please use the chat for any comments you may have and the Q&A for your questions, which will be addressed in the 20-minute Q&A session at the end of the webinar. I'd like to encourage you to submit any questions you'd like to ask and to kindly indicate which of the panelists you would like to answer your questions. To unpack today's topics, we are fortunate to have three distinguished panelists joining us. The first panelist will be Craig Clark, who is a professional engineer and an active member of the CESA Supply Chain Management Committee. Craig is a mechanical engineer with over 40 years experience in that field and is a CESA past president. Craig was extensively involved in the recent revision of the CESA Practice Notes. The second panelist, will be Francis Gibbs, who's a professional engineer and an active member of the CESA Supply Chain Management Committee. Francis is a civil engineer with extensive experience and was previously employed by Royal Haskoning, DHV. Of note is that he was greatly involved in the recent revision or updating of the CESA Practice Notes. The third and final panelist will be Dave Clark, who is a professional engineer and also an active member of the CESA Supply Chain Management Committee. Dave is a civil engineer with extensive experience, and he was the chairperson of the CESA Eastern Cape branch in East London for many years. I'd like to thank the panelists greatly for joining us today. They will each deliver their presentations, and at the end of the presentations or at the end of the webinar, there will be a question and answer session. Thereafter, the proceedings will end with some closing remarks. I'd like to just remind the panelists that they've each been allocated 20 minutes for their presentations. As mentioned previously, the first panelist to address us this afternoon is Craig Clark, who will speak on the topic Construction Commencement, Tender Award, Formalities, and Site Handover. Craig has kindly assisted CESA for many years now in answering questions from the members, and having authored the quintessential textbook, The Role of the Consulting Engineer During Project Delivery, there is no better placed person to address us on this topic. Craig's talk will be based on practice notes PN25 and PN51. At this point, I'd like to hand over to Craig. So it's over to you, Craig.
Hi, good afternoon, everybody, and welcome to the webinar. I hope it's going to be of interest. I must say that when I was given the task of presenting something on construction commencement, it was quite a task, in fact, to use a pun, to work out how to condense everything into a few minutes, 20 minutes, because construction management is a massive part of any consulting engineer's work, and to try and give you guys a feeling of what it's all about in just a few minutes is almost impossible. So what I decided to do was to just give a very brief overview and summary of some of the important things that happened during construction commencement. And as I say, it is certainly not party time. So where do we start? First of all, this little talk of mine actually covers two practice notes. The first one is the 25, and that deals with insurance of construction contracts. And the other one is a brief extract from PN51, which deals with the entire construction administration process. I'm going to be talking about services which are carried out by the consulting engineer during stages 4 and 5 of the 6 stages of a typical construction project. You are no doubt all familiar with the 6 stages as set down in either the CESA guideline scope of services or the PROXA guideline, and we're dealing with those 2 stages, 4 and 5. Now, there are really some important things that have to be done during this time, and if you don't do them properly, you could mess up the entire contract. And I use the word contract purposely because it's the contract between the employer and the contractor. And if you as the consulting engineer don't undertake your duties properly, what is almost certainly going to end up with is claims by the contractor and an unhappy client. So let's look at these things very briefly. The first one is the tender award process. The second one are the formalities to be undertaken by the contractor between tender award and before he gets onto site, and then finally site handover. So if we start with the tender award, please remember that the detailed processes will very much depend on the form of contract that you are using on your project. So if you're using the general conditions of contract, GCC, you will follow a particular process, while if you're using something like JBCC for building projects, then the process will be slightly different, but the general principles will remain the same. And what I've tried to do here is to keep everything generic. So obviously, if it's a public sector tender, don't forget to allow for the tender objection period. The next step in the process is to obviously to notify the successful and unsuccessful tenderers, and you will have to follow the procedures according to the form of contract. As I said, GCC and JBCC are slightly different. If it's a GCC contract, then you sign the form of acceptance and the price tender, and the contractor signs the form of acceptance and submits the price tender signed. Whereas if it's JBCC, the principal agent simply issues a letter of acceptance. And at that particular point, and this is quite an important concept to understand, up until now, he will use the information provided in the health and safety specification to do that. And as I said, in that health and safety specification, there will be input by you as the consulting engineer. Okay, so that's the first item that you must make sure is done. The second item is insurance. And this is a bit of a pet subject to me. And it's actually, as I said at the beginning, it is the subject of the first practice note. And I urge you all to go and read that practice note. I think it's practice note PN25, vitally important. And let me just absolutely emphasize that construction insurance is a specialized subject, and there are very few insurers and insurance brokers that have the expertise and skills to understand the requirements of construction insurance. And I just want to very briefly tell you an absolutely true story. It was a contractor very well known to myself personally, and he had an incident where 4 years after completion of a project, there was a failure, which resulted in a fire, and it was the contractor's fault. I mean, that was pretty clear that this latent defect had laid there for 3.5 years or 4 years before it was discovered, or became apparent and caused the fire. The contractor immediately made plans to start rectifying or repairing the damage on the site. But in the meantime, he also phoned his insurer and said, "Am I insured for this?" And his broker said, "Yes, you're insured, don't worry." And the insurer then said, "Well, you don't have to worry about doing the repairs. We will get them done," which the insurer did. They employed a third party to do it. And then halfway through all of this, it was discovered, no, the contractor actually wasn't insured for that particular item because of the fine print in the insurance policy, which said there was no insurance during the defects liability period, the latent defects liability period. And it ended up with the contractor paying another contractor for the repairs. So construction insurance really is a serious business. So be terribly careful. There are 4 basic requirements for the insurance. The one is the works insurance. The second one is, when I said requirements, I meant there are 4 components to insurance for projects. The first being the works insurance, the second being special risks insurance, SASRIA as we know it, which basically covers civil disobedience, and then thirdly, public liability insurance, which very roughly, if a third party comes onto the building site and a brick lands on that visitor's head, it will be picked up under the public liability clause. And then there is often other special insurance which may be applicable, such as lateral support insurance. There may be other client requirements and so on. So you have to be very, very careful because you must make sure the insurance is in place. It might even be that the client insures, but you must also be reasonably certain that the insurance is properly done. And you as a consulting engineer are not qualified to understand or approve insurance. So you need to make sure that the parties, the client and the contractor, check those policies properly and they take responsibility for it. Just be very careful about that. So make sure the insurance is in place, but don't get caught up in trying to check something that you're not competent to check. Then security, and that is the correct word. But as I said, the security could be in the form of a cash deposit. It could be a performance guarantee issued by a financial institution. And likewise, if there is a performance guarantee provided by the contractor, then the contractor is equally entitled to demand a payment guarantee from the client. Instead of guarantees, you can apply retention, or you can have a combination of any of those items. So, and sorry, yeah, the only other thing that I've been taught very carefully is only use forms of guarantees, pro forma forms of guarantees, as provided in your standard forms of contract. And both GCC and JBCC have provide pro forma forms of guarantee. Try and use those. Be very wary of forms of performance guarantees issued by financial institutions, because obviously they're trying to protect themselves, and they may well have fine print clauses which make these performance guarantees very difficult to enforce. Finally, the initial program. It's your responsibility as a consulting engineer to provide sufficient information to enable the contractor to prepare the initial program, and the contractor must then prepare the initial program, which needs to be done in accordance with the form of contract. So a form of contract provides the basic requirements of the initial program. You must make sure that is done. So once again, don't allow yourself to get caught up into doing the programming for the contractor, because you could very easily find yourself taking on responsibilities for something that you are not competent to do. So you provide sufficient information, and I mean the obvious information you would have to provide is a start date and a completion date, which would have been what the tender was based on, and then various other items of information to enable the contractor to prepare the program. And then finally, we get to the actual site handover. And the site handover, once again, is a very formal process. It's not something that you do casually. It's certainly not an excuse to have a braai. You organize a site handover meeting properly. You must make sure that all site information has been provided in the tender document, obviously. You must make sure that the parties are aware of that. You need to describe the site access. Just make sure that the employer is legally in possession of site, and that the employer has met all legal and environmental formalities. And yet another story I can tell you, which happened just a year ago, where a contractor, it happens to be the same contractor in the other story, he's had a hard time. He started on site with a large project. He was given the site, he started working on site, and about a month later, there was a dispute over non-payment, and it then came to light that the employer actually did not legally own the site, which obviously was extremely prejudicial to the because obviously now the employer was immediately in breach of contract. So make sure that you use the site handover meeting as an opportunity to set, what I say, set the rules of the game for the rest of the contract. It's a vitally important opportunity to make sure things are done. And if you start the project properly and formally, and you lay down the rules of the game, you will find that the rest of the project or construction period will probably go by very satisfactorily. But if you do it sloppily and things aren't done properly and the meeting is all casual, you're going to find that your project is likewise going to not function properly. So please be very, very careful. Make sure you run the site handover meeting formally and properly. Make sure and I hope you found it. And I'm sure you're going to enjoy the next two presentations.
Thank you very much, Craig, and thank you for sticking to your time allocation. Thank you for giving us really valuable guidelines and practical pointers on how to commence with or initiate the construction process. Craig's presentation, which will be uploaded to the CESA website, as well as practice notes 25 and 51, will undoubtedly prove to be invaluable to the member firms as they deal with the commencement of the construction stage. Next up is Francis Gibbs, who will address us on the topic Guidelines for Employers' Agents Representative on Works Contract. Through his many years spent in the consulting engineering industry, Francis has great experience and knowledge of contract management in our industry, and we are lucky to have him to share this knowledge with us today. His talk will be based on practice note PN 47. So I'd like to hand over to you, Francis.
Thanks very much, Wally, and good afternoon, everyone. It's a privilege to present to you today on the topic Practice Note 47, and as we've said, this is available on the CESA website under the Practice Notes. The purpose of the Practice Note is to provide guidance regarding the duties of the Employer's Agent, or EA, and the Employer's Agent's Representative, or EAR. You might want to shorten it to EAR, but yes, we want the guy on site to be the eyes and ears of the Employer's Agent, but for the purposes of this talk, I'll just refer to it as an EAR. And this is on an engineering works contract under the CESA General Conditions of Contract 2015. So it's not covering JBC, and I'm fortunately not covering FIDIC. This practice note deals mainly with GCC 2015. So what are the main functions of the employer's agent in terms of GCC 2015? They are to administer the contract as the agent of the employer, to monitor construction at the level agreed to with the employer, to appoint the employer's agent representative to represent the employer's agent in the above, and appoint other site staff to assist with the various tasks on site. And he can also delegate certain powers that he has as the employer's agent to the employer's agent representative in writing and notify the employer and the contractor thereof in writing. You might wonder why the terms engineer and engineer's representative were dropped in GCC 2015, and I thought I'd try and find out before giving you this presentation. And apparently it's to allow the GCC to be used on contracts other than engineering contracts. So perhaps where the QS is the employer's agent, and then he appoints a QS on site as well. So that is why the terminology has changed. I must say it's a bit of a mouthful, but anyway, we'll go forward with it. So what are the employer's agent's representatives' main functions? Apart from being a Rottweiler on site and making sure the contractor is sticking to the contract and the specifications, which will be discussed in the points below, he needs to ensure that the works meet the following requirements: safety regulations and plans. Well, the employer must also appoint a safety agent, and he is responsible for dealing with the contractor's safety representative and ensuring that the safety plan of the contractor and all the administrative requirements of the OSH Act and the construction regulations are met. But he might not be on site all the time, in which case the employer's agent's representative needs to stop unsafe working, needs to stop the work if there's unsafe working conditions or if the contractor isn't complying with his own safety plan. Similarly, with environmental conditions, there might be specific environmental requirements with regards to the construction works, and an ECO, environmental control officer, will normally be appointed on site. And this again might not be full-time, in which case the EAR must ensure that that the environmental conditions are complied with. He must ensure compliance with the program for construction and the contractual time limitations that might have been placed on the contractor, that the contractor follows the applicable laws, regulations, statutes, and bylaws, that he follows the way leaves and occupation permissions, or that these are in place and are applicable at the time that the contractor is doing the work. Sometimes these might expire if the contractor is running late. And of course, that the physical properties, dimensions, materials as per the construction drawings and specifications are met by the contractor. And of course, lastly, he must be able to ensure that the employer's agent's instructions are being followed. So the suggested approach is really to make sure that you're working as the engineer's agent representative in a good relationship with the client, following on your own responsibilities and your own authority. So, for example, if you have a request for where you require instruction from the employer's agent, you need to refer that to him, and where possible, give a list of options that will address the particular request. It's also very important to create a good working relationship with the contractor staff and, of course, other stakeholders in the contract, and adopt a positive, helpful attitude towards the contractor by assisting him overcome difficulties and without assuming the contractor's responsibilities. Of course, the employer's agent representative is quite within his rights to suggest ways and means of improving efficiency, but he must be careful not to step into the shoes of the contractor and avoid instructing the contractor how to carry out a particular operation, as this might come back to bite the engineer when the contractor puts in a claim saying, "I was told to do it this way." Also, it's very easy to say we must adopt a positive, helpful attitude towards the contractor on site, but as we all know, this is sometimes not the case, or it's difficult to maintain because you're being hit with a barrage of requests for information, which sometimes are spurious, requests for VOs and a lot of claims. And contractors seem to take much joy in filing correspondence to the employer's agent at a daily, if not twice daily rate. And so it's hard to be positive and friendly under these conditions. So the most important thing, though, is to make sure that the employer's agent representative and the employer's agent, of course, responds to all these items of correspondence timelessly. They must meet the contractual time so that the claims are adjudicated and the responses to requests for information are responded to. It's also very important that in amongst a whole bunch of spurious claims, to recognize that there might be valid claims, and the employer's agent and employer's agent representative need to adjudicate these in a fair manner. And that brings me to some do's and don'ts for the employer's agent representative. So the first do is to deal with all the contractors' measurements, accounts, and claims in a consistent, clear, and fair manner. Also, it's very important for the EAR to have a comprehensive knowledge and understanding of the contract documents so that he can act in accordance with them. Another do is to investigate and record circumstances and facts relevant to claims and record agreement or disagreement of these with the contractor. This is a requirement of clause 10.1.3, especially in the case of ongoing claims. And often the employer's agent representative does not proactively record facts and circumstances and get their agreement signed off by the contractor, and likewise sign off what the contractor is recording as a fact or circumstance relating to the claim. So you don't want to end up in a situation where you're in litigation and none of the facts and circumstances the contractor is putting forward are agreed to, and none of the circumstances or facts that the employer's agent is putting forward to are agreed to. So this is a very important thing that I'd like to stress, and I'm sure Dave will carry this forward into his talk on claims. Another critical aspect of the employer's agent representative duties is to coordinate the work of independent contractors. So on an unbundled or multidisciplinary construction project, there are often different and separate contracts carried out at the same time or in succession. In such cases, the employer's agent or the principal agent, in the case of a building project, is responsible for coordinating the work of the different contractors. And the employer's agent and the employer's agent's authority and that of the employer's agent's representative to direct such coordination must be contained in the special conditions included in the various contracts. So you must, and this is going a bit out of the construction stage back to the procurement stage where you're drawing up the tender documents, is you must include or allow for situations where things don't go smoothly as you would like. Perhaps the civil contractor is running late and the mechanical contractor is ready to start. And so it's important to do a risk analysis and to provide for these situations in the tender document that so that you can perhaps get the mechanical contractor only start at a point in time when the civil contractor is ready. So the other important aspect of the site administration is communication, and I want to touch on site instructions. So instructions to the contractor should really only be given by the EAR to the construction manager of the contractor. So it used to be the site agent. Now under GCC 2015, the contractor's site representative is a construction manager. So in general, of course, instructions should only be given in writing, but if verbal instructions are given, these should be followed up in writing as soon as possible thereafter. The site instruction book should be kept for instructions, dated and signed regularly by the EAR and the contractor. Okay, and then we all know these triplicate books where one copy goes to the engineer, one copy goes to the contractor, and the third stays in the book, so there's a good record. But perhaps that's changing. Times are changing. The digital revolution has spread to construction, where products such as Autodesk's Construction Cloud provide a platform for sharing of requests for information, site instructions, site meeting minutes, and other site communications in a secure manner. So you can specify which documents go to the contractor, which documents go to the client, and which are just kept amongst the employer's agent staff. So I think that's the way things are going. Obviously, on smaller projects, the contractor might be not be sophisticated enough to introduce such a thing, because generally it will be the contractor that introduces this. You might communicate by email. And while that's fine, it's just imperative that you then keep a record of the emails that are sent. You don't want that your employer's agent representative leaves the firm and his emails get lost, and now you can't dredge up the instructions that were being given by email. So you can either create a project-specific email address where you copy all emails to, which is something that's used quite widely, or you need to print out the emails and save them as if they were a site instruction. Okay, site meetings. Obviously, formal site meetings must be held on a regular basis, depending on the stage of the construction and the requirements of the participants. Sometimes in the beginning of a project, you might want to have them weekly or fortnightly, and then later on go to monthly. And you might also want to have separate technical meetings with the contractor, which perhaps don't have the client involved, and where you discuss the contractor's way of working or interpretation of the design and these types of things. But the employer's agent must ensure that site meetings are minuted and that the minutes are an accurate record of the proceedings. Minutes should be distributed to the parties concerned as soon as possible after the meeting, so that there's no excuse that they didn't know they had to do something, but certainly prior to the next meeting where they are approved or corrected. And it's also important to, there's often a misconception that minutes have a strong legal standing, and in cases I found that that's not the case. So the minutes serve as a record and often used as a basis for adjudication if disputes should be declared later. However, you shouldn't rely on site meeting minutes to inform or instruct the contractor, and you should always communicate such matters formally, such as with a site instruction or in a letter to the contractor. There is a draft agenda provided in Practice Note 47, which is quite comprehensive, which you can use for site meetings. So that's something to refer to there. On quality management, I think that's often why we have the employer's agent representative on site, but he must obviously become familiar with the design and technical specifications of the works to be able to do quality management. And he should note and list all the items which need to be checked. For example, the setting out. It's usually a requirement that the employer or the employer provides the benchmarks for the contractor to then do a setting out from. And so it's important that these are in place, shown on the drawings, and are correct. And if you need to have a site surveyor, sometimes there might be a site surveyor who assists the employer's agent with this, and we don't rely on the contractor surveyor. The contractor will set out all the necessary lines and levels required for the proper control of the works using the above these beacons and benchmarks. But the employer's agent representative needs to conduct a completely independent check at suitable intervals to satisfy himself as to the efficiency and accuracy of the contractor setting out. We've all seen these pictures of bridges that have been built, arch bridges that have been built from two sides that don't meet in the middle, or tunnels that miss each other completely. So you really want to avoid those sorts of situations, and checking by the employer's agent representative is one way to get around that. On the matter of temporary works, it's not really the employer's agent or the employer's agent's representative to design temporary works, but the recent collapse of the false work on the what's it called, Greyston Road Bridge, highlights the perils associated with temporary works. So it's really important from employer's agent's point of view that the design of the temporary works is at least checked, and any queries are referred back to the designer of the temporary works. So you will not be taking responsibility for the design. Well, you must ensure that you're not taking responsibility for the design of the temporary works, but you need to have looked at it and satisfied yourself as the employer's agent that it's been done competently, that it's been done in a professional manner. So I think that's the key thing with temporary works. And if you need to refer stuff back to the designer, it must be done. And of course, the contractor must then build the temporary works in the way it's designed, and that's also something that the employer's agent can have a view on, even though again needs to avoid responsibility. Authority to proceed with the work. So when you're covering up foundations, for example, or you're covering up pipeline, or before you cover up, rather, you need to be able to give the contractor the go-ahead to do the cover-up. It needs to be that you've checked the foundations or the pipe joints or whatever it is that you need to check before it's covering. So you need to have hold points in the program where the contractor waits or doesn't wait, as the case may be, for the engineers, see, I'm trapping myself here, for the employer's agent's representative to approve the work. And then the procedures for inspection and testing of materials. Obviously, these will be specified in the specifications, but you need to sort out on site how these tests will take place, what frequency, and for a particular structure, for example, and that the specifications are adhered to. Okay. So I mentioned earlier the importance of keeping a record of facts and circumstances relating to claims, but the employer's agent's representative must ensure that there's much wider reporting that's carrying on, and generally these will include daily and weekly site diaries, records relating to weather conditions and time lost, quantities of hard and soft excavation, rock levels, a photographic record of construction progress that's often helpful in claims. And now with drone technology, drone technology is being used more and more frequently to capture progress on site in a way that's hard to argue against. He should prepare progress reports and, of course, have an up-to-date drawing register that everyone is working off the same version of the drawing. And again, that's where a BIM or a data management system that's shared between the contractor, client, and consultant comes into its own. Okay, financial control. So this is a normal service under EXA Stage 5 services that is often overlooked by the employer's agent and the employer's agent representative. The employer's agent representative, or I suppose the employer's agent, should prepare and maintain a financial control system and report on a regular basis to the client. A projected final contract value should be included in the financial review using the anticipated final quantities and allowing for escalation, VOs, and claims. And the client needs to be placed in a position to obtain additional funding for the project, or if he elects to leave out parts of the work, to stay within the current budget. This is very important now with the limitations on contract extensions that Treasury places on local authorities and public sector clients. So they may not go above 25% of the awarded contract value. If you are tending towards the 25% limit, you must give the client ample warning to go and apply to Treasury for an extension above the 25%. Or he might elect to leave out part of the works or put it in a later contract if it's a multiple phase project. So, so these financial reports are very important in this case, and it often happens that, well, it doesn't often happen, but let's say in circumstances it can happen that the quantities haven't been measured that accurately, or there's things have changed and there's a lot more rock than was anticipated, and now the contract price is escalating and approaching, well, it's escalating. I mean, any escalation of the contract price needs to be awarded, needs to be notified to the employer. And so what often happens is the financial or the anticipated contract completion value is not checked looking at what is changing on the contract. It might just be that the employer's agent representative is looking at the certificates of the contractor, the interim measurements made by the contractor, and just plodding along, projecting that no, we won't exceed the quantities at the end of the job. Meantime, there's things happening that are changing that. So it's very important that the employer's agent representative is proactive in looking at what the likely final quantities are going to be, so that the final contract price can be estimated beforehand, timeously, and notified to the client. And this touches on measurement. Well, what I was saying now touches on measurement, and I think often you see that the extent to which the employer's agent representative relies on the contractor's measurements. In fact, it is the EAR's responsibility to measure the works. Okay, but you can request the contractor to carry out the measurement in your presence. So that you ask him to, you might need some laborers to help, tape measures, etc., to measure something, or you need a survey, and then you can sign off on that particular measurement. So the only measurement that the contractor does is the measurement for the interim payment certificates. And I think I know probably most of you know that, but it's quite clear in the conditions of contract. And then final quantities should be agreed with the contract possible after the relevant item or section of work is completed. You don't want to again end up in a situation where something's covered up and you're arguing about what the quantities were. So it should be agreed with the contract as soon as possible. Okay, and this is my last slide. It's just a caveat to consultants. Or the extra guideline gives 5% enough to cover your duties during the defects liability period and the closing of the project. For example, you might need to allow for additional site visits to verify rectification of defects and carry out the final inspection. There might be ongoing mechanical, electrical commissioning problems, for example, in a pump station or wastewater treatment works. You need to complete the as-built drawings and O&M manuals, and the actual process of issuing the final approval certificate and the final payment certificate. So it's important to do a risk analysis at the end of the, or shall we say, when the completion certificate is issued, and see, well, how much money do I need to provide to close out this project properly, that you don't end up with a big loss for the last part of the project. Okay, so that's my presentation. Thank you very much, and I'll hand you back to Wally.
Thank you very much, Francis. It was a great presentation. Thank you. Thank you for so ably presenting on this topic and including practical guidelines and tips for the employer's agent's representative, or as you said, on a works contract. Your presentation and Practice Note 47 serves as a valuable checklist for members newly entering our industry or existing members about to take on this role. As previously mentioned, the presentation will be available on the CESA website under guidelines, then presentations, and then the practice notes. CESA tries hard to empower members with useful information through its practice notes and through webinars such as this one. Moving on, our third and final panelist to address us this afternoon is Dave Clark, who will speak on the topic Contractors' Claims under GCC for Construction Works, the third edition, 2015. Now, through his many years spent in the consulting engineering industry, as well as in the contracting sector, Dave has great experience in managing contractors' claims, and we are lucky to have him to share this knowledge with us today. Now, his talk will be based on Practice Note 23. And Dave, it's over to you. Thank you.
Thank you, Wally. Good afternoon, everyone. as Wally said, this is based on the contractors claim and practice note 23, and we're going to talk about contractors claims under the CESA General Conditions of Contract for Construction Works, 3rd edition, 2015. Now, this is an extensive subject. If it isn't dealt with properly, it'll lead to disputes, and there are a number of very highly qualified people who have a career in dispute resolution, and you will end up paying 3,000 Rand an hour for their services. So while this is, we're going to talk about GCC 2015, the claims for FIDIC contracts should be dealt in a similar manner. I don't have much experience on JBCC or NEC, but I'm sure there are people within CESA who do have that kind of experience. So contractors' claims are often unavoidable. They can result in the actions or omissions of 3 parties: the contractor, the employer, or the employer's agent. The employer's agent must not take the view that a claim reflects badly on their ability to design and administer a project. It's just a fact of life. It is important to stress at the site handover that the GCC 2005 clauses of the contract will be strictly applied. This will make quantification and ruling of any claim on the contract more manageable. If contractual procedures are followed, the parties will be in the best position to accept a satisfactory ruling on a claim. Now, GCC 2015 says the employer's agent is obliged to adjudicate claims fairly and without bias, whereas FIDIC says the engineer shall act for the employer and make a fair determination, but it doesn't say anything about bias. Examples where claims can arise out of actions and or omissions of the employer. Supplementary conditions of contract in the contract data may create an ambiguity and unintended consequences. If the scope is amended, always scope for a claim. Unforeseen physical conditions, such as rock. We've just recently done a jacking under the R59 where the borehole drilled on either side indicated no rock. However, we hit rock the entire way through. Unforeseen existing services. Nowadays, there are very few people that have institutional knowledge of the services within the municipalities because of the high staff turnover. So it's very difficult to know where the services are. Another claim situation is where the failure of the employer to respond timeously. The request for an acceleration of construction of the works can also lead to a claim. Early taking over the works by the client can also be a claim-related issue where responsibilities now become mixed. A delay in obtaining the construction work permit has led to claims, which has now prompted myself in certain instances to change the commencement date on contracts. So the commencement date is the date of issuing of the construction work permit. We've had contractors putting in claims for months while they wait for the construction work permit, which is obtained for them by the employer. Another problematic area is labor rates, building fora, and the 30% subcontractor requirement. Quite often the client gets involved in trying to specify these things, and then the contractor finds this a reason to blame the employer for delays. Examples which claims can arise out of change of legislation, pandemics. The COVID one in particular is recently have an instance where the contractor claimed extension of time and costs for COVID. We certified it. The client refused to pay it. It went to adjudication and the adjudicator ruled in favor of the contractor. So those are unavoidable and surprising things that happen, and The contract, in fact, GCC 2015 covers pandemics, whereas GCC 2010 didn't. Additional special non-working days, then a new date for an election is always leading to a claim for an extra costs and time. Labor rates, there are statutory wage rates for the construction industry, but sometimes the municipalities specify a lower rate for the contractor, and this can lead to ongoing disputes and claims. Examples where claims can arise out of acts and omissions of the employer's agent, errors in drawings, omissions in the bill of quantities. Quite often the consultant will write a specification saying how he would like a certain item in the bill to be done, but he neglects to put it in the payment refers column. And then there's a huge fight as to should it be applied or should it not be? So just be very careful if you're compiling a bill of quantities that you actually put the right references in the payment refers column. That'll lead to, so it'll save a lot of trouble in future disputes. Changes in specifications, maybe a change of pump or change of pipe, often leads to claims. Failure of the employer's agent to respond timeously, that always leads to a dispute. Contractors will submit claims, and some of these will be excessive, fraudulent, or spurious. I had to explain to one of the contractors what spurious meant. Spurious is, in the dictionary, says it's basically fraudulent or manufactured. However, many claims will be genuine. The contractors spend time and money on labor, materials, and plant, and wishes to be placed in at least the same financial position he had before the disruption or delay event occurred. So he's out of money, and he will claim because he's out of money and time. Examples are numerous and quite unexpected. A very common one is access to site, where you think you've got access to the entire site. Recently, we went on to site on a contract and we found we had only access to 10% of the site due to a farmer disputing and wetlands, and so immediately we got into a claim situation. Design errors and omissions always lead to problems. Omissions or changed quantities in the bill of quantities. Now, FIDIC specifies you cannot change a quantity by more than a certain percentage. And then as soon as that happens, you can get into a claim situation. I don't think GCC is quite as prescriptive as that. Changes to specifications, unforeseen physical conditions, changes in legislation. It's important that the contractor notifies the employer's agent in writing of his intention to claim. You mustn't, the contractor shall not write to the client or whoever, because they often try, they even write to the project steering committee to try and initiate a claim. It must go through the right channels, and that the employer's agent is that channel. There's a set procedure to be followed by the contractor and the employer's agent for a claim to be considered. The contractor must notify the employer's agent in writing within 28 days, setting out the full particulars of the claim and list the circumstances giving rise to the claim. Now, sometimes he might not be aware of the circumstances. So what they say in the GCC is he should notify the employer's agent within 28 days of when he should have become aware of the circumstances giving rise to the claim. Now, that's quite subjective. So, and that can also lead to a dispute. If the claim is ongoing, the updated particulars relating to the claim must be submitted on a monthly basis. Now, this is quite often missed, and it's a very important point because your claim could be, the claim could be ruled invalid if you don't submit a monthly claim. At the end of the events leading to a particular claim, the contractor has 28 days to submit his final particulars of that claim. That's to do with ongoing circumstances. Failure to adhere to these timeframes could lead to the claim being time barred by the employer's agent. Now you can, by mutual agreement, change these timeframes. And it's quite often necessary because sometimes you cannot actually determine all the facts and circumstances of a claim. The employer's agent's power to rule on claims may well be limited by the employer, either in the professional services agreement with the employer or as laid down as special conditions of contract between the employer and the contractor. And this is done to ensure the employer has control of the budget. In the GCC, in the guidelines, the GCC, it lists maybe 30 different items where the powers of the employer's agent could be limited. But generally, the most important ones I find are variation orders, extension of time, and reduction of penalties, all of which have got great impact on the cost of the project. There is also a contractual obligation in terms of clause 3.2.2 of the GCC 2015 for claims to be discussed between the employer, the contractor, and the employer's agent. We recently had a circumstances where the employer was actually totally absent from the project. He kept on paying, but he never attended meetings, he never responded to letters, and we had to continue in good faith, and we had to write letters to actually just cover ourselves. The GCC does say the employer has an obligation to take part in the contract, and if he doesn't, you can actually terminate the contract. But in this case, we didn't terminate because he kept on paying, and then we thought, well, because he's paying, he actually wants the contract to continue. The contractor's claim should be presented in terms of clause 10.1 and 10.2 of the GCC in the following manner. You must give circumstances leading to the claim, a motivation on the merits of the claim, a historical list of events, a basis for the extension of time, if applicable, a cost calculation, if applicable, supporting documents properly identified and numbered. Now that's quite important because if you don't document properly, when it goes to adjudication, you're going to be struggling to get sufficient evidence in support of either the claim or refuting the claim. And those documents can be lever arch files full of stuff. So it's very important to document properly. The contractor may not consolidate claims. Each claim must be presented individually. So you can't combine rock and labor dispute and anything together. It's got to be each on its own. The claim can be twofold, as I've said before, time and or additional payment. The engineer's representative must review all claims in terms of the following: the validity of the claim. Has the contractor met the contractual obligations? And the merit and the quantum. Is it technically sound? Is it financially sound? Is there financial reason to award financial compensation? Often a delay being claimed by a contractor runs concurrent with one or more of his own delays, and then it will not be valid. Now, what can happen too is the contractors could be laying a pipeline and it's not on the critical path, but he drags his heels and goes very slowly till it finally does run into the critical path. He would not be entitled to an extension of time claim for his own bad workmanship. So it's important to go back to the approved construction program to determine if the claim is valid, if the pipeline now is on the critical path or not, and should he be paid. To look for concurrency of claims and to ensure timeframes are met, it is useful to prepare an Excel spreadsheet reflecting the date of the claim, the response date required, and then put for each respective claims to have a column which running through the months, so you can compare this column with that column to see whether the claims are concurrent. Also on that same spreadsheet, you should have the non-working days, the statutory non-working days, such as the Christmas break, pay weekends, rain events, so that you can compare column for column to see if a claim is actually valid. Useful tools to evaluate a claim include the employer's agent's daily diary and the contractor's daily diary. You've got to be very careful with these because we were working down at Val Marina and we had a tornado hit and the whole contractor's site camp disappeared somewhere in the Val Dam. So we lost the employer's agent's diary, lost the contractor's daily diary. So a very good thing is to every day to actually photograph it or scan it and send it to the head office to be filed. These are critical issues when responding to a claim. Obviously, site meeting and technical minutes are important. Photographic evidence, the camera never lies. Tally sheets. I was given tally sheets when we were doing some emergency work over leading up to Christmas to make a site safe, and the contractor had to import G5 material from commercial sources. So he produced the tally sheets for these for the G5 material. So I looked at them and I said, I want delivery notes. He says, you want delivery notes? I said, yes. So it took a few days and the delivery notes duly arrived. So I said, okay, so you're telling me you've got a 7-minute turnaround from here to the quarry, 40 minutes away. So he had fraudulently produced delivery notes. So it's very good to have tally sheets. You can quickly work out whether someone's trying to be fraudulent. What we do regarding correspondence and emails, make sure you have delivered receipts. Now, in your emails, at least make sure that you click the delivered receipt button. You might not always get a read receipt from whoever's receiving the emails, but a delivery receipt is sufficient in law. So make sure you ask for a delivery receipt and save that delivery receipt. Don't just get it deleted or put it in a folder and save it. You never know when you'll need it. Site instruction books, of course, are critical in terms of claim adjudication. And then also contractors generally have a request for information book, RFI as they call them. And those are very critical because the contractor might have requested something and the employer's agent might not have responded, or the client has failed to make a decision. So that's also very critical in adjudicating claims. So this is my final slide. Failure of the contractor, failure of the employer's agent to rule timeously can lead to an interest claim from the contractor. Failure to rule at all signifies the claim is rejected, and that may lead to a contractor declaring a dispute, and that could lead to mediation, adjudication, arbitration, or court. So I think sometimes employers' agents get lazy and they don't respond in time. That really reflects badly on the professional team if they don't respond in time. Generally, a contractor has had to tender optimistically as he needs to submit his lowest price to win the tender. And this places financial pressure on the contractor when unforeseen events occur. So it's not surprising that you get claims. Sometimes the contractor is underquoted and will look to claim his way to a more profitable position. I think we've all been there. And most important of all, don't carry baggage. Don't let emotions get in the way of good practice. If you had a bad experience with a contractor from previous times, you've got to put that one side. You can't let that get in the way of adjudicated claim. So make sure that you rule timeously, in a fair manner, and without bias. I think, Wally, I'll hand back to you.
Thank you, Dave, for an excellent presentation on this topic and including practical guidelines and tips on good business practice in managing contractors' claims. Your presentation serves as a valuable checklist for members managing construction contracts. And again, as previously mentioned, it will be available on the CESA website. At this point, I'd like to pose the question submitted by the delegates to the panelists for their response. But before I do, I'd like to inform you that you are welcome to email me any questions you may still have or were not answered during the webinar. And my address is wally@cesa.co.za. And of course, we will see that they are answered. So now going to the questions, let's just, first one we have is from Anonymous. It says, what happens when an SOE or municipality does not provide you with an unsuccessful letter or notifies you of the result of your tender within the 14-day objection period? What measures can an objecting bidder take to inquire about the results of the prospective bid? And as it was the first question, Craig, I think it was during your presentation. Would you care to answer that question, please?
Thank you, Wally. And I must say that question's caught me a little bit by surprise. I said I was giving a very brief overview. And I wonder if perhaps Francis or Dave could answer this better than I can, because I personally do not have a huge amount of experience in public sector procurement, and one of them might be better qualified to answer the question. Obviously, the what's the right word? The complaining tenderer should write to the client or the principal agent, but I'm not sure if there's an exact procedure laid down. Francis, I see you've switched on. Would you like to answer?
Yeah, I can't comment on in the case of a contractor, but I can comment in the case of a consultant where the award has been queried, and eventually there was no response from the client, and a letter under the Access to Information Act was sent requiring the client to provide the adjudication. So so that is your sort of, shall I say, your last step in this process if you need to access the information, if you think. But obviously there's all kinds of risks with that. You can turn the client against you, and there's also the chance that you aren't the preferred bidder anyway, and you're not going to get anywhere with this line of action. Thanks. I don't know if that answers the question.
Yeah, I think it does, Francis. Thank you very much. You know, we've got at least 10 questions, and we've got a reduced question time. So brevity is our watchword. So the shorter the answers, the better. I do want to say, though, that members of CESA are encouraged to write to CESA and make use of CESA to intervene in cases where you have problems with procurement. provided that they are of a general nature, like what we've just discussed, CESA can object on your behalf and retain your anonymity. In other words, we just write to the SOE or municipality and say that our members have encountered this problem and ask for their, for their attention and rectification. Okay, thanks. The next question is from William Kennedy. He says, is a letter of good standing with COID, which is compensation for occupational injuries and diseases, is a letter of good standing for that required? I'm not sure if that's one of your questions, Craig.
I can, sorry, I'm just moving my screen. I can possibly answer that. If it's a requirement in the tender document, then yes, it is a requirement. It would have to be stated in the tender document as a required document. And I do not believe that if a tenderer omitted to include that letter, whether that would normally be grounds for disqualifying the tender. If the letter of good standing is not submitted with the tender, the engineer can ask for it. If it's not then provided, then certainly the tender could be disqualified. I don't know if that answers the question.
I think that's an excellent answer, Craig. Thank you very much. Then we have it was listed under chats from Naomi Faree, but I think the question's not quite complete. I think what she's asking is, what about environmental considerations at the commencement of construction? For you, Craig.
Oh, sorry, Wally, I was looking at a written question here. I wasn't listening to you. Sorry, please repeat.
Okay. So Naomi Faree asked, what are the environmental considerations at the commencement of construction?
Again, that's not really a question that I'm qualified to answer, but generally speaking, if the project requires an EIA, then I would say that EIA, the approval of that EIA must be submitted before the contractor commences on site. And I think most projects these days on greenfield sites require an EIA. So yeah, that I hope is an adequate answer.
Thank you. That's fine by me. Thank you. Then there's a question about the presentation notes. Copies of the presentations will be available on the website. If you want more detail, then you can go to the practice notes. But other than that, or you can write to me, and then it's wally@cesa.co.za, and we'll try and make sure you get that. There are some quite difficult questions in my view, because there's limited space to write about performance securities and guarantees and the dates of expiry and so forth, that I think they mainly come from one person. So we'll take those offline, I think, in the interests of time as well. Lero Todi Malete asks, where the EAR cannot verify setting out, can EAR state in the quality form that all setting out and levels have been checked by the contractor surveyor, and therefore no responsibility will be taken by the engineer? I'm not sure if you heard that, Francis. I think that's one for you.
Yes, I did hear it. Thanks, Wally. I think the important thing in a case like that is to anticipate in the tender document that the EAR won't be able to confirm the setting out, and to place the responsibility totally on the contractor. The alternative to that, if you are in a situation where the EAR is unable to check the setting out, is to bring in a surveyor as a as a once-off to do the checking. Hope that answers it. Thanks.
That's a good answer. Thank you very much. And then a follow-up to that, Francis. If two contractors are working on one site, making use of a phased or staged approach, how do you best recommend that risk management be dealt with?
So the important thing about risk management is it's done again at tender stage. You will have both you'll be preparing both the tender documents for these contractors, or however many there are, and obviously the critical points are the interfaces when the works gets handed over to the other contractor, or when the other contractor gets called in. For example, a mechanical contractor has to come and install pumps. And so the important thing is to also get the client on board, because often as the employer, they'll award the mechanical contract just because they want to get it, follow their processes. And when it would be better to delay award of the contract for some time until the civil works is ready. So you need I think important thing is to do the risk assessment at tender stage, to be aware of what can go wrong, to have a discussion with experienced members of your team about what can go wrong with regard to contractors going late or other issues, and to write that into the document, and also to get to make sure the client or to try and get the client to agree not to award shall I say, the second coming in contract until the first contract is ready to receive it. Yeah. Thanks.
Okay. Well, thank you very much for that. Just a last one for you, I think, Francis. It's a bit of a philosophical one, I think. Should we, it's from Andres, should we as consultants not move totally away from the word check to the word review pertaining to construction monitoring? The legal fraternity understand the word check in a very strict sense. It tends to result in a higher level of responsibility for us than what we are prepared to accept.
Yeah, that's a very good point. I mean, that's why we've gone away from the term supervision to monitoring. Is supervision and monitoring are also two different things. So yes, I agree with that. If you can get away from from attracting responsibility in the terms that we use, then we should be progressing that way. Thanks.
Yeah, thank you for that.
Could I add
yes.
a very brief comment?
Yes.
I think it's a very good question, and I think it's worth reading very carefully the CESA guideline scope of service, which describes the requirements for construction monitoring very carefully. And I would also just like to say that I think when the new CESA guideline for 2022 is published, you'll find the wording is even better improved in that. So follow that, and it's a very important question. Good question.
Okay, thank you, Craig, for adding your bit there. This one's for Dave Clark, I think. It's from an anonymous viewer. I'm seeking clarity on the application of performance bond and retention. As a form of security, can you have both the guarantee and retention? And then if a contractor chooses the withholding of retention money in place of a bank guarantee, is the retention going to double? Dave?
Okay, I'm afraid my video won't go on. I think the host has blocked my video. But yeah, you can have both retention and guarantees, and it is double. Okay, there we go.
Okay.
Sorry, I was busy trying to do that. Why don't you read the question to me again, because I was busy.
Okay.
Start my video.
Okay, it's from Anonymous. It says, I'm seeking clarity on the application of performance bonds and retention. As a form of security, can you have both the guarantee and the retention? If a contractor chooses the withholding of retention money and in place of a bank guarantee, is the retention going to double?
Yes, so the retention definitely doubles. You do have a performance guarantee and a retention. Now, there are instances where certain clients will waive one of the two, but generally I don't like that. Normally the retention is 10% up to a maximum of 5%, and whether it's a performance bond or a cash guarantee, I don't believe we should waive it. And then, so I think it is double. Yeah, it's quite an onerous thing. And as I say, some clients will actually waive one of the two. I don't know if that answered the question.
That is an excellent answer. Thank you, Dave. At this point, we've still got many more questions. So I think I'll discuss it later with my principals, but I think we will just answer the questions and make them available to viewers and members who attended the seminar, and possibly we will list them together with the presentations. But I think we promised viewers an hour and a half. We've almost reached our limit, and there are just some closing remarks that I'd like to say. So friends and colleagues of CESA, we've reached the end of the webinar, and I'd like to thank the panelists for availing of their time and for sharing their knowledge and thoughts with us. And of course, a big thank you to the delegates, our delegates, for supporting CESA and attending our Practice Notes webinar. Before we close our session, we'd like to invite you to submit any comments or suggestions you may have regarding these Practice Notes webinars, with a view to improving them and making them more useful. You're welcome to suggest topics that you'd like addressed at future webinars. And again, you may send me your comments and suggestions at wally@cesa.co.za. In closing, I'd like to kindly request delegates to complete the satisfaction survey that will pop up on your screen, and the web link will also appear in the chat room. The purpose of the survey is to provide us with your satisfaction ratings or feedback that will enable us to improve our future webinars. Delegates registered with EXA may claim 0.15 CPD points for attending this webinar as per our webinar attendance list. And for ease of administration, CPD certificates will be sent to delegates upon their completion of the survey. As a very last point, sorry, it's just admin, we would like to ask members to regularly check their spam or junk folders for CESA correspondence in case it has ended up there. We'd also like to request that you whitelist the email addresses that CESA uses. With that, thank you again for your attendance and participation, and I'd like to wish you a good day further. Goodbye.